So, Jeff, from a constitutional perspective, I'm curious how you view this decision yesterday from the Supreme Court, 6-3 on ideological lines. This distinction that they try to make, or that they're actually going to leave others to make, between official conduct of the president, official acts of a sitting United States president, versus private or personal conduct, effectively saying you've got free reign under official conduct, but who gets to decide what that is, and how do you make that distinction?
That's the crucial question. And in fact, the dissenters say that it's completely unclear how lower court judges are supposed to distinguish between official and unofficial conduct. And as a result, the only clear thing that's immunized is the president's conversations with his former acting attorney general. But when it comes to his conversations with the vice president, with state election officials, his tweets, it's up for grabs. Different courts could disagree about what is official and unofficial. And the result, says Justice Sotomayor in her dissent, is a radical aggrandizing of federal judicial power, basically consolidating power in federal courts and ultimately the U.S. Supreme Court to decide what's official and unofficial. And what's so remarkably striking, and I hope that citizens will read the majority opinion and the dissent, because it really is for the ages. The majority says this is required by our text and history and by Alexander Hamilton's desire for a vigorous executive. The dissent say Hamilton went on to argue in Federalist 77 that the president is amenable to prosecution. And as a result, the so-called originalist justices have completely made up this new, novel, and textually untethered principle and distinction between official and unofficial action that has no basis in the Constitution.
So, Jeff, Jack Smith may try to go forward. We have no reason to believe he won't at this point, but it'll be a different case, obviously. It'll be pared down because of exactly what Joyce just laid out. Some of the evidence now may be covered under presidential immunity after yesterday's ruling. So how do you see yesterday's decision impacting not just that federal election case, which now Judge Tanya Chutkan, the U.S. federal judge, the district judge, has to go through and decide what's covered and what's not? It's left to her, but also the classified documents case down in Florida, another federal case, and the state case in Georgia. How do you see yesterday impacting everything downstream?
Well, it'll make all of them very, very hard to proceed with. There's an interesting footnote in the immunity case yesterday that notes that last week in the Fisher case, the U.S. Supreme Court drove a stake through the heart of two of the charges that Jack Smith is bringing involving violations of the Sarbanes-Oxley Act and destroying documents in connection with January 6th. So the judge in the Smith case has to first decide whether those charges can succeed, and then for the remaining charges in that case, as in the other ones, decide on a case-by-case basis, were the president's communications in office related to official acts? Were they on the periphery of those actions, or were they completely private? And judges could disagree in each of those cases. Each of those rulings could be appealed up to the U.S. Supreme Court. And the result is making it very, very difficult to prosecute the president. And that brings it back to the central theme in our conversation today, which is accountability. Peter Baker mentioned it. You mentioned it. And Justice Ketanji Brown Jackson mentioned it in her remarkable dissent, where she said the individual accountability model embraced by the framers of the Constitution assumed that the president isn't above the law and has to be accountable to criminal law like every other citizen. She cited framers from Alexander Hamilton to James Wilson to Charles Pinckney to James Iredell, and insisted that this is a violation of a basic principle at the bedrock of the U.S. Constitution. And the result is that courts, in particular the U.S. Supreme Court, has the final word, and that Congress can't enforce the criminal laws. And in practice, it will be extraordinarily difficult in the future to prosecute former presidents.